Good morning, everybody. The hour of 10 a.m. having come and gone, the International Relations, Tourism, and Trade Committee will come to order. Thank you all for being here today. We are convening a subject matter hearing on House Bill 2723 today. Now, I want to make it clear there will be no vote today. What a subject matter hearing does is it gives a chance for legislators and the public to hear from experts, proponents, and opponents of the bill. This is an important, so for an important issue like this, it's important that we understand all sides and all facets. I recognize that this issue carries significant emotional weight for many people on both sides of this issue, and I'm sure for most of you here. The testimony we'll hear will touch on deeply held beliefs, lived experiences, and concerns that extend into our communities, our economy, and our relationship with partners around the world. Because of that, I understand that feelings may run high today, but I intend to keep this committee's focus on what we have been charged with, looking out for the safety, welfare, and the well-being of the people of Illinois. We have a responsibility to conduct our work with professionalism and respect, and to assure that every voice can be heard. To do that, we must maintain order in the room. There will be no public comment. You have already done that by filing an opponent and proponents, and I will tell you, there is, as of my last count, 15,199 proponents and 11,781 opponents and 44 no positions. We will not be allowing any outbursts, applause, or commentary from the gallery at this time. These will be disruptions, and what I want the people on both sides of this issue to feel comfortable to speak. If there are any problems, which I'm hoping there will not be, the offending party will be asked to leave. If they will not, they will be escorted out and maybe charged with trespassing. So please, we do not want to do this. What I want to do is to be fair to both sides and let the arguments speak for themselves. So with that, we'll be having 7 witnesses today. Sarah, oh no, we're going to take it. Hold on one second. Okay, clerk, please take the roll.
Bella.
Here.
Shearer. Sosnowski. Crespo.
Are these people?
Ellick.
Hold one second.
Here.
Sosnowski is here on Zoom. He's
Sosnowski present.
Yep.
Okay, got it. Hawes.
Here.
Kiker.
Kiker's here.
Kelly. Manley.
Manley's here.
Mason. Olacombe.
Here.
Ryan.
Here.
Smith.
Present.
Spain.
Spain is here.
Stevens.
Here.
Tarver. Walsh. (11) present.
Thank you very much. So today we will be hearing from 7 witnesses and the proponent. The 7 witnesses will be Sarah Van Loon from the American Jewish Committee, Dan Goldwyn from United Jewish Fund, Rebecca Weininger of the ADL, Martin Levine from JVP Chicago, Richard Goldwasser, former J Street Chicago Chair, former J Street National Board Member, and Yasmin Elaga, Community Representative. Sorry if I mispronounced any of the names. We will be also hearing from Dr. Ken Kitts from the University of Illinois Springfield, Distinguished Professor of Public Administration and Director of the Institute for Illinois Public Finance. With that, let's begin, and as the sponsor of the bill, Representative Rashid is recognized to lay out what the bill does and why he filed it.
Yeah. Good morning, everyone. Chair Vella, Vice Chair Shearer, Minority Spokesperson Sosnowski, members of the committee, thank you for the opportunity to present HB 2723 this morning. I want to begin by recognizing the advocates, community members, and colleagues who built momentum for this bill, and to thank the chairs of the Black, Latino, Asian, and Progressive caucuses, the Deputy Majority Leader, and the dozens of lawmakers across both chambers who have already signed on. This support reflects a broad understanding in the General Assembly that Illinois is on the wrong side of a problem we created and that we have an obligation to fix. You'll hear from 3 other witnesses today besides me, and I want to tell you upfront who they are so that you understand why I'm going to leave certain things to them. You'll hear from Marty Levine, who spent 50 years as a Jewish institutional leader in Chicago, including 4 decades helping build what is now the largest Jewish community center system in the United States. Marty will tell you from inside the institutions who conceived of the policy we're working to repeal, how it was conceived and whose interests it was actually built to serve. He will also share the words of Israeli leaders, former intelligence chiefs, former generals, leading Holocaust scholars, who have said in public, in their own newspapers, what their own government is doing. I'm going to leave that material to him. You'll hear from Richard Goldwasser, a Chicago attorney of 35 years who clerked for the president of the Israeli Supreme Court and chaired J Street's Chicago chapter for a decade. Richard will speak to the broader picture, how a law like ours, now copied by many other states, corrodes the democratic rights and values that define this country. I'm going to leave that argument to him. And you'll hear from Yasmin El-Agha, who will speak to the human reality of what this law shields from peaceful protest. I'm not going to try to do justice to that. I'll leave it to her, and I'll ask you to listen to her with the same care that you give to every other witness today. What I want to do in the time I have is 2 things. First, I want to tell you who this law is about, not in the abstract, but in concrete terms. And second, tell you what this law actually does. I was born in Chicago. When I was 5 years old, my parents put my siblings and me on a plane and we moved to our village in the West Bank called Tormosaya. It's about an hour's drive north of Jerusalem. My grandparents are from there. My great-grandparents are from there. My great-great-grandparents are from there. My entire lineage on both sides, for as far back as is recorded, is from there. I lived there until I was 11, and I've been going back every couple of years for my entire life. The village is built in a valley, stretching into a hillside of the West Bank. The houses are stone. From my family's roof, you can see mountains, the neighboring village, olive, fig, and almond trees, schools, and the hustle and bustle of village life. Some of those trees are more than 1,000 years old. My family has tended to some of them for hundreds of years. In October and November, when the olives are ready, almost everyone in the village stops what they're doing. Everyone goes out to the trees. You spread tarps under the branches, you comb the olives down with your hands, the kids run between the rows, and at the end of the olive harvest, you press the oil. You eat dinner outside, you give jars of oil to neighbors, to relatives, to the family members who flew in from Chicago or Amman or New Jersey. That is what a Palestinian community looks like when nobody is interfering with it. It is people on their land, learning to love the traditions that have been passed down from their parents and grandparents, raising their children to do the same. Palestinians are a people who love education the way some people love sports. My parents had nothing when they got here. They built a life so that their children would be educated. Every Palestinian family I know aspires to this. Education was the inheritance my parents fought to give me and my siblings. And it is the inheritance that people of my village and Palestinians across the West Bank, Gaza, and the diaspora have always given their children, even when the school is a flimsy tent. We are also a tight-knit community. If you're a Palestinian in Chicago, you almost certainly have cousins in both hemispheres. And if we can't keep in touch, our aunties keep us in the loop. The young man who was killed in our village 3 summers ago, Omar al-Quttain, had family in Oak Lawn, right here in Cook County. The father of 5 who was killed in the West Bank last year, Khamis Ayad, had family in Cicero. A Palestinian child whose skull was fractured last year by Israeli settlers is about to graduate high school in a few weeks in Bridgeview. That's not a coincidence. That is a community that has held itself together across borders, across oceans, across a century of pressure to break apart. I tell you all of this, the trees, the harvest, the education, the family ties, because everything I'm about to say to you about this law makes sense only if you understand that this is who the law is about. We are not an abstraction. We are not a line item in a foreign policy debate. We are a people. We are members of your communities. We send our kids to the same schools you send your kids to. Our children play soccer and basketball with yours. And many of us, like me, grew up partly here and partly there, with one foot in Cook County and one foot in a village that has been on the same hillside since before the United States existed. Now I have to tell you something harder. There is a project to make sure the village I just described to you does not exist in 50 years. It is a project to take the land. It is a project to take the trees. It is a project to break the connection between the Palestinians of Cook County and the Palestinians of the West Bank, to make sure my cousins' children do not inherit the orchards their great-grandfathers planted, to make sure that fewer of us each year can go back, to make sure that what remains of our community in our homeland is eventually quietly gone. This project is not a secret. It's conducted in broad daylight by a foreign government that says publicly what it intends to do. Its current finance minister has stood at podiums and said that there is no Palestinian people. Its current security minister has been convicted in Israeli court of supporting terrorism and lives on land that was taken from a Palestinian village. The settlers who attacked my village in 2023, hundreds of them in broad daylight, were not arrested. They were protected by Israeli soldiers. That is not an accident. That is the policy. The law I am asking you to repeal today is one of the tools of that project. It's not the most violent tool, and it's not the most visible tool, but it is one of the tools, and it's the only tool that has Illinois' name on it. Here's what the law actually does. In 2015, this state created a body called the Illinois Investment Policy Board. The law gave that board power over investment decisions affecting more than $120 billion in public pension assets, the retirement security of nearly 895,000 Illinois public employees, retirees, and beneficiaries. Then the same law did something extraordinary. It exempted the board's decisions from the ordinary fiduciary duties that every other body managing public retirement money in this state is required to follow. The board has no duty to ask whether a divestment is good for retirees before forcing it. It has no published standards. It has no formal appeal. It has no audit. It has no annual report. A 7-member politically appointed board, exempt from the most basic legal protection owed to the workers whose money it controls, has the unilateral power to force the sale of pension assets if it decides, without standards and without explanation, if it determines that a company's business decision to boycott Israel is, quote, politically motivated. The statute does not define politically motivated. That phrase, the trigger for the entire enforcement machinery, is left to the discretion of the board. And what is the board's actual mission? Well, the chair of the board's Israel Boycott Restrictions Committee, in writing, in correspondence later released through public records requests, described the mission as, quote, preserving Israel's sovereignty, including over the West Bank. That is the documentary record. That is not what an anti-discrimination law does. That is what a foreign policy enforcement body does on behalf of a foreign government, paid for with the retirement savings of Illinois teachers and bus drivers and judges. Marty Levine will walk you through that record in more detail, but I want you to hear that phrase in writing from the man the board put in charge of its Israel boycott enforcement work, and I want you to hold that letter, that language, next to the institutional letter you've received that calls this an anti-discrimination law. The architect of the law itself is a man named Richard Goldberg. He drafted it as a staffer for Governor Rauner. He has spent the years since then at a hawkish foreign policy organization called the Foundation for Defense of Democracies, where he's currently a senior advisor. He has spent the last several years publicly advocating for war with Iran. He appeared on television in March of this year to comment on active US and Israeli strikes on Iran, the same strikes that, according to Pew, 61% of Americans disapprove of, the same strikes that have driven gas prices in this state up to almost $5 a gallon, which is quickly making life even more unaffordable for Americans and Illinoisans. That is the architect of the Illinois statute. He still publicly boasts that Illinois was the first state to pass this kind of law and that many other states have copied it. He's continued to lobby the board he helped create, including in 2022 through a formal memorandum to the board demanding it move against Morningstar, an Illinois-headquartered company, for the supposed crime of providing accurate environmental, social, and governance research, ESG research. So when I describe this as a partisan board carrying out a political project, I am not using a figure of speech. I'm describing the documentary record. The board has been used repeatedly to coerce American companies, San Francisco's Airbnb, Chicago's Morningstar, into changing their lawful business practices to align with the foreign policy preferences of a foreign government. It uses the retirement savings of nearly 900,000 Illinoisans to do so. And it does all of this without the basic fiduciary duty that protects every other dollar of public pension money in this state. This is not a policy. That is a censorship practice. You will be told that this law applies only to foreign companies. That is not true. The chief Senate sponsor of the original 2015 statute wrote to the board in 2018 that the so-called U.S. company protection, in his own words, was non-binding. And he urged the board to use the law against San Francisco-based Airbnb. And the board did. That is documented. The same year, the board moved against Chicago-based Morningstar. The board did not blacklist Morningstar in the end, but only after Morningstar agreed, under the threat of forced divestment, to eliminate its human rights index entirely. That is state coercion of an Illinois company, headquartered just a few blocks from where I sit right now, by a board operating under this statute. The "we don't go after American companies" claim was disavowed in writing by the man who passed this law. You will be told that this law fights discrimination. The man the board put in charge of its Israel boycott enforcement work said in writing that its mission was preserving Israeli sovereignty over Palestinian land. The statute itself protects from boycott not only Israel, but in the words of the law, territories controlled by the State of Israel. That phrase covers occupied Palestinian territory that the United States itself does not recognize as Israel, and that the International Court of Justice declared to be illegally occupied. That is not anti-discrimination policy. That is foreign policy, specifically the foreign policy of a foreign government, with Illinois pension dollars conscripted to enforce it. You will be told that repealing this law means Illinois is now boycotting Israel. That is also not true. HB 2723 does not engage the state of Illinois in any boycott of any country. It does not direct our pensions to divest from anybody. It simply restores the ordinary state of affairs that exists for every other country in the world, that companies are free to make their own commercial decisions on their own moral and business judgment without retaliation by the state of Illinois. We do not punish companies for boycotting Canada or France or our own government. The only country in the world singled out for that protection in our pension code is Israel. HB 2723 simply ends the misguided practice of retaliating against peaceful protest. And finally, you will be told that opposition to this law is opposition to the Jewish people. I want to address this directly, because it is the argument many opponents most heavily rely on. You'll hear in a few minutes from two Jewish witnesses who came here today to testify in support of repealing this law. One spent 50 years as a Jewish organizational leader in the state. The other clerked for the president of the Israeli Supreme Court and led J Street Chicago for a decade. The premise that the Jewish community speaks with one voice on this question is not true, and it has never been true. And it is especially not true today, when polling shows growing majorities of American Jews opposing shielding Israel from accountability. In recent weeks, 7 of the US Senate's 10 Jewish members voted to block bombs from going to Israel. And just before I entered this hearing, I learned that Evanston Mayor Daniel Biss, soon to be congressman, just wrote a piece endorsing HB 2723. I want to come back briefly to where I started. In the summer of 2023, I visited my childhood home of Turmusaiya with my wife and our 3 young children. It was supposed to be a vacation. Early in the trip, hundreds of armed Israeli settlers invaded our village in broad daylight. They shot 12 people. They killed Umar al-Quttain, who had family in Oak Lawn. The next day, some of the same settlers came back, this time toward our neighborhood. When the shooting started outside our house, my then 7-year-old daughter clung to me and asked me a question. She looked at me terrified and asked me a question that broke my heart. She said, "Dad, what do we do if we get shot?" She's 10 now. She's with us in this room today. She remembers that. The settlers who terrorized our village, who killed Umar, who scarred my daughter, under Illinois law as it stands today, peacefully boycotting them is a punishable act. Companies that decline on moral grounds to do business in their settlements lose access to nearly 900,000 Illinoisans' retirement money. The settlers who killed Khamis Ayyad, a father of 5 from Cicero, under Illinois law as it stands today, are protected from peaceful boycott. This is not theoretical and it's not symbolic. This manifested in real time when Ben & Jerry's decided to boycott those settlers. They made a decision based on their morals to not sell ice cream in illegal Israeli settlements. They were even going to continue to sell the ice cream in Tel Aviv, just not Israeli settlements. And they were punished by the state of Illinois via divestment for taking this basic moral stand. That is what we are discussing today. Not foreign policy in the abstract, rather the question of whether the state of Illinois will continue to risk its pension health to shield the settler terrorists who killed Umar al-Quttain and Khamis Ayyad against any company that in the most peaceful way available to it declines to participate in enabling that violence. I told you who Palestinians are. I want to tell you briefly what is happening to us. The schools and universities that mean so much to us are being deliberately erased. Every one of Gaza's 12 universities has been destroyed. Schools sheltering displaced families have been bombed. Community leaders, doctors, journalists, professors are being targeted. Doctors have been lined up and shot. More journalists have been killed in the last 2 years during the genocide in Gaza than in the United States Civil War, both world wars, Korea, Vietnam, and Afghanistan combined. The olive trees I described to you, those are being uprooted in front of farmers who planted them generations ago. The villages I described to you, those are being raided in broad daylight, like mine was, by armed settlers who are protected by the state. Yasmin will speak to what this is doing to ordinary Palestinians. I'm not going to do what she's going to do, but I want you to remember when she speaks that this is what Illinois law currently shields from peaceful protest. So, I am asking you to repeal this law. This law uses the retirement security of teachers, university workers, state employees, and judges to punish peaceful protest. It coerces American companies, including Illinois companies, into changing their lawful behavior to satisfy a foreign government. It declares a single country in the world, alone among all countries, exempt from the most basic forms of nonviolent protest. And it does all of this with no fiduciary duty, no formal appeal, no audit. We can repeal it. We can take Illinois' name off of a project that is one of the tools Israel and its ideologically motivated supporters are using to erase Palestinians. When the transcripts of this hearing are read years from now by our children and grandchildren, when they're read by my daughter Alia, who once asked me what to do if we get shot, what would you like the record to reflect? I'm asking you to advance HB 2723 out of committee. Thank you.
Thank you, Representative Rashid. Before I ask for any questions, could we add Representative Kelly, Ellick, and Olakol to the roll? So does anybody have any questions? What we're going to be doing is, between each set of speakers, we're going to be asking questions. Does anybody have any questions for Representative Rashid? No? I do have one question for Representative Rashid, if it's possible. The bill removes the Israel-related, and I was reading it again last night, but it doesn't remove, there are other countries, Belarus, Russia, Sudan, Iran, it does not remove them from the list. Could you just talk a little bit about that?
Sure, that's a great question. So those are a fundamentally different category in how the underlying law actually treats them. Those countries are required to be boycotted by Illinois law. A company domiciled in Russia or Belarus must be boycotted. Israel is the only country that cannot be boycotted. That is a critical distinction. It's actually the exact inverse. It's the exact inverse. Thank you for that question.
Thank you. Representative Kiker?
Thank you. Thank you, Representative, for presenting this today. Just curious, as I look at the list of witnesses and everybody that's testified here, I think it's a glaring absence that we don't see the Treasurer's office here to give any testimony. Is that an oversight on our part? Was there something up to that point in time to speak to what the state of Illinois has experienced on his end?
So this doesn't directly address the Israel bonds issue that has been the primary purview of his office.
Okay.
This has to do with our pension assets, TRS, SIRS. Yes, it's specifically to the pension code, not Israel bonds.
Okay, thank you.
Any other questions? No? All right. Thank you, Representative Rashid. Next, we'll call up Ken Kritz from the University of Illinois, Springfield. Yeah. And I think we have a PowerPoint, is that right? Oh, she'll set it up, okay. Push the button. Yep.
Push the button. All right. So thank you very much for inviting me here. My name is Ken Kriz. I'm a professor at UIS. I also am testifying as a person who's served on the investment committee of a number of city pension plans and also was on the advisory board for the supplemental retirement plan for the university. So I've been doing research on pensions for over 20 years and have practical experience that's about 15 years worth. So, and I want to thank you for inviting me. Again, I'm testifying as a neutral. I take no position on the bill or the original restrictions. I was just asked to come and talk about some of the potential effects as far as the research has shown. So, first slide. So, I'm sure that you kind of know this, but I just wanted to make sure, when I was a pension trustee, I did take an oath of fiduciary duty when I was sworn into to serve on the committee and served on the investment committees. And I took it very seriously. And so what pension trustees do and what pension plans do is they do something which in academics we love to come up with these kind of $10 phrases for these things. So what we practice is what's called mean variance optimization. So what is that? Well, basically for a given level of return, so say we have to hit a 7% return or a 6.5% return, we try and minimize the variance of the portfolio. So the annual fluctuations, the up and downs of the value of the portfolio. Said another way, if we have an acceptable level of risk, we try and maximize the return on the portfolio. That's what we did. That's all of our conversations were about that on the boards on which I served. Why do we do this? Well, quite obviously, what we're trying to do is allow either or both the maximum level of benefits for the employees or the minimum cost to the taxpayers, because there's this third party that very few people talk about when they talk about pension plans, and that's the taxpayers, because they're going to have to come up with the money if there's a shortfall in resources for the plans. Next slide. Oops, sorry. So just to talk about the restrictions in general in doing the research on this topic, there's basically three broad categories of restrictions. So the first one are certain asset class type restrictions. So when I was on the board for the city of Omaha many years ago, one of the council people didn't like commodity investments. They thought that they were excessively risky. So they had a prohibition passed so that we couldn't invest in any commodities. And there's similar restrictions out there for things like private equity funds, hedge funds, things like that. The second type might be called issue or security constraints. So this quite often takes the form of saying you can't invest in an asset that has a single issuer. So the best example I have of this is a lot of investments in things like farmland or structured loan funds have one particular company that they're associated with. Those restrictions are pretty obvious why they're there. You don't want necessarily any one particular investment to be made in a company. It has all kinds of problems with transparency and accountability. And then the final type are the ones that are represented and what are being discussed here, and that's either sector or country screens. So sector screens will often take would take the form of a prohibition on things like energy investments, or either a requirement to invest in ESG type investments, or a requirement against investing in ESG, and states have actually passed kind of both of those, and different cities have also. And then obviously the anti-boycott provisions are the ones we're talking about here. Next slide. So what has the academic literature found when I do my research on this topic? What has the literature found about the effects of restrictions in general? Now I'm going to talk in general. Right now, I asked for a list of investments that had been foregone because of this, and I was not made privy to such a list. And so it's impossible for me to do my own study to figure out what the potential effects might have been in Illinois. But in general, there's been any number of research papers out of organizations like the World Bank, the National Bureau of Economic Research, and several top universities that have found a pattern. In general, when restrictions are put in place, what we tend to see is poorer, what we call risk-adjusted returns. So again, for a given level of risk, what were the returns? So I gave you the example of the commodity restriction that was on the Omaha plan. Commodities are a relatively risky investment class by themselves, but they have this property, sorry to again get academic on you, but it's called negative correlation. They're negatively correlated with other assets. And so by putting a risky asset like a commodity into a pension plan, you can actually reduce the overall portfolio risk, because as other investments go up, they go down. As commodities go up, the other investments go down. And so that actually kind of evens out. So there's that effect. There's another effect called benchmark drift. Now, all pension plans have to manage against benchmarks. So, for example, on each of the plans I was on, our large cap US equity investments, we benchmarked to something called the Russell 1000 index. It's very similar to something you might know, the S&P 500. Okay. Small cap US were benchmarked to the Russell 2000, international to something called the MSCI index, things like that. When you start removing categories or individual investments out of the portfolio mix, suddenly you're not mirroring your benchmark. And so tracking performance against kind of an objective benchmark becomes a lot more difficult when you do that. And so that creates some problems with, again, managing risk and return in the portfolio. And then finally, the last one are increased administrative costs. You have to have increased costs of monitoring to make sure there's no investments going into a certain asset or something like that. Again, increasing the cost just reduces the benefits you can offer or increases the cost to the taxpayers. Now, there is one mitigating factor that I wanted to point out in the pension code. As I read through the pension code, there is an exclusion for indirect holdings of assets. So an indirect holding would be if a fund invested in a certain asset. So think of it like a mutual fund. That's actually not the way that pensions hold their investments, but it's the closest corollary I can come up with. If a mutual fund invested in an asset of a certain type, they wouldn't necessarily be required to divest. That makes the effects likely to be a lot less than the effects that have been seen in other research. And so with that, I hope I've increased kind of understanding of the role of pensions and what pensions are trying to do and what effects restrictions in general might have on it. As I said, I have no position on the particular bill.
Thank you very much. I do really appreciate you coming up, and I really appreciate your testimony. It is a complicated issue. I will open up to any questions anybody has. Representative Kiker.
Thank you, Ken. Appreciate you being here. Just on one of the answers or information you provided, you didn't get a response from any opportunities foregone. Was that due to a confidentiality restriction? Was it a no response? What was the nature of that?
I made the request through the counsel for the committee, and it wasn't provided. I have no idea what.
No reply.
No reply.
Oh, okay.
Lost the All right, seeing no other questions, thank you very much for that. I really appreciate it. And to the committee, I think we all have that in our email, so if we have any more questions, we can just take a look at that. Next, we're going to hear from the proponents. Who would like to go first? Please go ahead.
Thank you. My name is Marty Levine. I'm going to need some glasses. I'm a career Jewish communal worker. That for all of 50 years of my working life, that's all I have ever done. It's what I did for 40 years, leading the Jewish community centers, now the Heckman Family Jewish Community Centers of Chicago. That work prompted my deep commitment to building a strong, vibrant, and living Jewish community and connecting it to the community I served. In that role, I worked very closely in Chicago with the leadership of the Jewish United Fund, with the leaders of other communal organizations, and with many religious leaders. Those 40 years in the Chicago community, I think, provided me a unique opportunity to understand the inner workings of the Jewish community, and to some extent how this law came to the state legislature and how it was passed. I'm appreciative of the opportunity to speak because for me, Israel has always been important, but what Israel is today is also a travesty of its vision and dream, and it is time to address what this law is doing. I know how central Israel is to so many in my community. I learned firsthand that many of my professional colleagues in the work of serving the Jewish community, many of those who lead legacy Jewish organizations, and many of the men and women I pray with weekly have struggled to accept that the Israel of their dreams is not the Israel that we heard about just minutes ago from the representative. They struggle to see Palestinians as a people with a claim to the same land my Jewish community claims as a homeland. They have struggled to accept that Israel was not living up to the noble words of its Declaration of Independence. It was not a land, and I'm quoting from that document, of complete equality of social and political rights. They struggle to see the harm that Israel does every day. For those who claim to speak for the Jewish community that I worked alongside, Israel could do no wrong. Myths became truth. Of a land without a people, for a people without a land, and anxieties that Israel could be a Jewish state or a democracy, but not both. Those concerns were pushed to the back of our collective consciousness. It was very difficult in that environment to speak words that ran upstream from that common belief. Against this context, the Palestinian people, which included substantial Jewish and Christian populations, stopped being friends and neighbors. Instead, they were reduced to an obstacle, an existential threat to the fantastical dream of a Jewish democratic state. As public consciousness grew, the push became to pass this law that we are now talking about repealing in Illinois. The impetus for this effort was to support Israel's increasingly aggressive efforts to destroy a Palestinian future. This we know from the public 2018 email from Andrew Lappin, who served in the leadership position of the Jewish United Fund of Metropolitan Chicago and was the first chair of the IIPB's Israel Boycott Restrictions Committee. That memo went to Jay Takath, who is a senior JUF executive responsible for public policy agenda. Mr. Lappin said very directly, protecting Israeli sovereignty, particularly as regards Judea and Samaria, was the goal of this effort. And that represents the policy of organizations which have said, we stand with Israel, even in the face of the brutality that is a daily experience. This was not about protecting the Jewish people. This was about protecting an Israeli government and its expansionist desires at the expense of the Palestinian people. From 2005, when the Palestinian civil society representatives first issued their call for a boycott of Israel, a demand that only asked that Israel comply with the international law and with the universal principles of human rights, until 1914, when the effort to combat it reached Illinois, the call for boycotting Israel was becoming louder and louder from those who saw the reality of the Israeli state. BDS, by its very nature, a nonviolent political strategy, was seen by those who saw any protest of Israel policy or action as an existential threat to the status quo. It was seen as so much of a threat that the Israeli government began to spend money to combat it. That amount I read yesterday has grown to almost $750 million in the current Israeli state budget for quote-unquote foreign public relations efforts. And Illinois became ground zero for the legislative maneuvers to construct legal hurdles to effectively outlaw the boycott movement. The potential of a mass movement, a peaceful mass movement, standing up and saying Israel is an oppressor, was a threat to the status quo of Israel. It was a threat because it is nonviolent. It's a threat because it relates Palestine to other oppressed people. It is a threat because it calls for equality. It is a threat because it does not demonize the cause of the Palestinian people. And BDS boycotting was particularly scary to those who saw their purpose as protecting Israel no matter what. Nonviolent protest for the rights of the oppressed had a great resonance in our country. We can remember that in 1955, Rosa Parks refused to give up a seat on a segregated bus and launched a 13-month boycott of the buses in Montgomery, Alabama, protesting white racist oppression of her people. That was the beginning of an effort that still goes on, but an effort to make this country live up to its dreams. We can remember that in 1959, an international movement began calling for the boycott of the apartheid regime in South Africa, which, after years of struggle, proved to be successful. Again, an effort to overturn an oppressive regime that resonated deeply for many of us. And let's be clear, since 2014, things have only gotten worse in Israel. Israel has become clearer about its desire to crush the will and the body of the Palestinian people and forever divorce them from their land. The brutality of the occupation has become unavoidable. By 2021, things had gotten so bad that one of Israel's most respected civil rights groups, B'Tselem, published a report telling the world all Palestinians living under Israeli rule are treated as inferior in rights and status to Jews who live in the very same area. This, they said, represented apartheid. That same year, the International Human Rights Organization, which the United States government, until the Trump regime, relied on for definitions of what violated human rights, reached a similar conclusion. In 2024, the International Criminal Court issued indictments of Israel government leaders for war crimes. And just days ago, the world-renowned Israeli Holocaust scholar Omer Bartov, who recognized that Israel was committing war crimes and acts of ethnic cleansing in Gaza, made this statement in an interview in the English language edition of the Israeli newspaper Haaretz, and I'll quote him. Zionism is an ideology didn't run its course. It became something I don't recognize. It became the ideology of the state. And it became not only militaristic and expansionist, but also racist, extremely violent, and ultimately an ideology that deeply harms both the individual and the collective. Such an ideology has no place. The law that we're asking you to repeal is a law that makes it difficult to protest that behavior by the Israeli government. Earlier this week, Tamar Pardo, who was the former chief of Israel's Mossad intelligence agency, said what he witnessed during a tour of the occupied West Bank reminded him of the treatment of the Jewish people during the Holocaust by the Nazi regime in the 1930s and 40s. The law we're asking you to repeal protects that behavior. Those are scholars. That is a leader of Israel's former leader of Israel's intelligence agency. Things have not gotten so bad that words that were written in 1967 by the Israeli novelist Amos Oz resonated loudly because it spoke to both Israelis and Jews, and I want to quote him at some length. He wrote right after the 1967 war and the occupation of the West Bank, Gaza, and the Golan Heights by Israel. We were not born to be a people of masters. To be a free people, this wish must awaken and echo in our hearts so long as we have not lost our humanity. We are condemned now to rule people who do not want to be ruled by us. An occupation is inevitably a corrupting occupation, and even a liberal and humane occupation is an occupation I have fears about, the kinds of seeds we will sow in the near future in the hearts of the occupied. Even more, I have fears about the seeds that will be implanted in the hearts of the occupiers. I see no validity in the annexation of populated regions to the bounds of the State of Israel without the agreement of their inhabitants. The residents of Nablus and Gaza are not human material, they're not human dust, they're not subhuman rabble who have to be expropriated so as to create living space. And that leads us to what we're talking about this morning.
I don't want to cut you off or slow you down, but we've only got so much time, so if we could just try to get quickly to the point, yeah.
Keeping the status quo continues to lead Israel down a path of punishing protected speech and nonviolent protest. It is in the same vehicle that President Trump's order this week to punish green card holders for speaking their political views represents. Those telling you that this law should stay in place want to depict BDS as something other than nonviolent. They say or hint that it is anti-Semitic. They say or hint that it will lead to violence. What they don't say is what Andy Lapin said years ago, that the purpose of the law is to support Israeli policy, no more, no less. We all must recognize this and not make it harder for those who see inequity and raise their voices in protest, in peaceful protest. You do not need to agree with them to protect the rights to protest peacefully. It is never too late to correct the mistake. In 2026, Illinois can and must act to erase this dangerous law from the books. Thank you.
Thank you very much. Before we go to the next speaker, I just wanted to Representative Kiker's question. I did check with committee staff. Committee staff reached out to the investment board to see if they could testify about the question that they had, and they decided they didn't want to attend, and we just found out about this morning, so I just want to let you know. On the next one. Richard. And again, I don't want to shut anybody down. It's just we only have so much time, so if you could just get to the point as quick as possible. I know it's hard. I know this is a very emotional topic, so please, if you can.
I appreciate that. First, I'd like to thank everyone here for the opportunity to speak this morning in support of HB 2723, introduced by Representative Abdelnasser Rashid.
I'm sorry, could you introduce yourself?
This is my next line. My name is Richard Goldwasser. I grew up in Skokie and now live in Highland Park. I've practiced law in Chicago for 35 years. One of my first jobs was clerking for the appellate court judge, Don Rizzi, right here in this building. My legal career began in 1990. Shortly after I took the bar exam in July, Iraq invaded Kuwait, which was the start of what became known as the Gulf War. Within a week, I was in Israel, where I clerked for the president of the Israeli Supreme Court. And each day I carried a gas mask to and from the courthouse. After a year in Israel, I returned to Chicago, intending to pay off my student loans, and moved to Israel. Life, however, had other plans. I met my wife, Deborah. We started a family, and I stayed. I did manage to pay off my student loans, something that at that time a young person could reasonably expect to do in short order, though that's a story for another hearing. Over the past 2 decades, my wife and I have raised our 2 daughters, Ilan and Ari, in Highland Park, and have been members of a conservative synagogue. During this time, I served 6 years on the national board of J Street, a pro-Israel, pro-peace organization, and until last fall, I chaired its Chicago chapter for a decade. I share this background because there is a persistent perception that Jews are of one mind on Israel, and that criticism of the Israeli government is inherently anti-Semitic. That is simply not the case. In fact, a poll conducted after the 2024 elections showed that 90% of Jewish Americans believe that someone can criticize the Israeli government and still be pro-Israel. And we're not talking about milquetoast criticism either. According to a Washington Post poll from last September, 61% of Jewish Americans believe Israel has committed war crimes against Palestinians in Gaza, and 39% believe Israel's actions constituted genocide. These criticisms are not fringe. They are located well within the mainstream of American Jewish opinion. Having laid out my pro-Israel bona fides, something that I confess I find somewhat distasteful, but necessary in a climate where some voices are privileged over others, such as Yasmina Lara, who sits to my left, I turn to the substance of my testimony. In 1967, Israel launched a preemptive war against Egypt, commonly known as the Six-Day War. By its conclusion, Israel had defeated Egypt, Jordan, and Syria, and had occupied the Palestinian territories of the West Bank, East Jerusalem, and Gaza. From the outset, some observers recognized the profound dangers inherent in a prolonged military occupation, not only for the occupied, but for the occupier. Simply put, occupation corrupts. And we see that corruption today in the daily violence carried out by Israeli settlers against Palestinians, burning homes, displacing families, and in some cases, taking lives. This says nothing about Israel's actions in Gaza, which raises grave concerns and deserves a hearing in a different tribunal. For present purposes, I want to highlight a warning issued in 1967 by Yeshaya Leibowitz, an Israeli Orthodox Jewish public intellectual. He said, "A state ruling a hostile population of 1.5 to 2 million foreigners would necessarily become a secret police state with all that implies for education, free speech, and democratic institutions. Leibowitz understood that sustaining an occupation would require suppressing dissent, that people of conscience would inevitably organize and speak out, and that democratic institutions, including the judiciary, would come under strain. For those watching the events in Israel, his warning resonates powerfully today. Now consider a parallel closer to home. In 1966, black citizens in Claiborne County, Mississippi, presented local officials with a petition demanding racial justice, desegregation, fair employment, and equal access to public accommodations. When those demands were ignored, community members voted to boycott white-owned businesses. The boycott was effective. In response, business owners sued the NAACP and others, winning a substantial judgment. But the U.S. Supreme Court ultimately reversed that decision, and NAACP was claiming that political boycotts are protected under the First Amendment rights of free speech, assembly, and petition. The court emphasized that the practice of persons sharing common views, banding together to achieve a common end, is deeply embedded in the American political process. Indeed, boycotts have been central to American history, from the Boston Tea Party to the Montgomery bus boycott led by Dr. King. They are a foundational tool of democratic change. So how did I come to testify here today? For many years, I believed that Israel's occupation of the Palestinian people was immoral, not only because of its impact on Palestinians, but because it threatened Israeli democracy. I hoped that by ending the occupation, we would preserve that democracy. Over time, the occupation deepened, now encompassing over 6 million Palestinians living under Israeli military rule for nearly 6 decades. And I came to see another consequence, its corrosive effects reaching the United States. Leibowitz's warning now applies here. Today, more than 35 states punish Americans for engaging in political boycotts targeting Israel. Illinois, a blue state, my state, our state, was the first of them. This is deeply troubling. First and foremost, the anti-boycott law makes Illinois complicit in the occupation. It directs our pension system to punish any company whose collective conscience leads it to withhold commerce from Israel or the territories it controls, the legislative euphemism for occupied Palestinian territory, where millions live under military rule without political rights. The corporate decision to withhold one's commerce as a matter of conscience is precisely the kind of action the Supreme Court vindicated in Claiborne Hardware. Illinois has put itself on the wrong side of that principle and on the side of the occupier. And the harm radiates outward. The statute that forced Illinois to dump Unilever stock because Ben & Jerry's would not sell ice cream in the West Bank settlements is the model on which more than 35 other states have built their own anti-boycott regimes. Illinois went first. Illinois licensed the rest. This is the corrosive effect of the occupation washing up on American shores, and our state's name is on the door. Punishing the politically motivated boycotts, the tool the Supreme Court protected in Claiborne, is of a piece with the growing fascism in our country. Using the state of Illinois' investment power to shield Israel from the cost of denying Palestinians their political rights while punishing those engaged in boycotts violates the very First Amendment, the freedom of expression the First Amendment was meant to protect. And this constitutes a double foul. I support HB 2723 because it seeks to correct this wrong. It reaffirms the fundamental American right to political expression and restores a vital tool of democratic participation. Thank you.
Thank you very much. Next. And we'll have questions after this panel.
Good morning. My name is Yasmin Al-Agha. I am a practicing attorney, although I almost wasn't. On the heels of my graduation from Northwestern School of Law, I was defamed, fired, essentially excommunicated from the field I worked my entire life to enter. And it is precisely because I am Palestinian and a Palestinian from Gaza who exercised her right to free speech. I am originally from a city called Khan Yunis in southern Gaza. My family has been in Khan Yunis for over 500 years, and we are one of the largest families in Gaza. My grandmother's home in Khan Yunis was housed inside a centuries-old Ottoman palace called Al-Qal'a. When I first visited Gaza as a child, I was introduced to generations of new family members, loving souls who playfully chased my siblings and I around the maze of the palace. When we grew tired of hide and seek in the sprawling compound, we quenched our thirst with fresh fruit juice from the local bakery and devoured clementines and persimmons from the fruit stands that lined the bustling streets. This is the beautiful Gaza that I know, one that laughs, plays, and brings color to life. This, like the rest of Khan Yunis, is all reduced to rubble. Over the past 2 years, I have watched my family members be picked off one by one under the torrential downpour of Israeli bombardment. Over 200 of my family members were killed. Some were elderly, many were mothers and fathers, about 50 were children, the youngest of whom was only a few months old. In the weeks leading up to their senseless deaths, they suffered immensely. Hundreds of my family members were displaced, sleeping on pieces of cardboard in the cold streets, taking refuge in hospitals that were bombed and schools that were nevertheless targeted by Israeli airstrikes, leaving them begging for their lives. My 81-year-old relative, Jawdat Al-Agha, was one of those displaced. They found his body curled in on itself, looking for any morsel of warmth, but frozen to death. A few months later, 2 of my elderly relatives found their neighborhood flooded with Israeli forces. To venture out for food was to sign their own death sentence. They put out a desperate plea for food as they starved while trapped in their home. We have not heard from them since and can only assume the worst. Those who did venture out for food faced a similar fate. 2 of my mother's cousins left their home to search for desperately needed food. They came back to discover that Israel had destroyed their home in an airstrike, killing their mother, father, and sister. As the surviving brothers desperately dug through the rubble by hand to find any body part of their loved ones to bury, another Israeli airstrike dropped on their home, killing them both. The only surviving member is one sister outside of Gaza, who never had the chance to dignify her family with a burial. She is orphaned of her mother and father, forever deprived of her siblings, shuttered from any opportunity to bid farewell to the entire family that Israel ripped away from her and left utterly alone in the world. This is not an exceptional circumstance. This is the double taps that we hear about in the news that target humanitarians, aid workers, doctors, journalists. This is a matter of state policy. Yasser and Ru'a Al-Agha were 2 other siblings, aged 6 and 14, who were also killed by Israel. Their area was so flooded with Israeli forces that their family could not reach their children's dead bodies until 1 month after Israel killed them. Ra'a and Yasser's bodies were so decomposed that their eyeballs were decayed and emptied from their sockets. This is the lasting memory that their little brother, who screamed at the gory sight of his dead siblings, has of them. The elderly in my family have not been spared. The children in my family have not been spared. And the mentally disabled in my family, similarly, have not been spared. My uncle Man has a severe mental disability that leaves him dependent on medication to function. The blockade on entry of aid into Gaza included this medication. After running out of it early after the Israeli violence began, he experienced severe withdrawal symptoms. When my aunt Samar went out in search of his medication, she was shot at by Israeli tanks and witnessed others in the street killed in front of her. Man was later taken hostage by Israeli forces, who also took my American cousins, 19-year-old Burak and 20-year-old Hashim, and their Canadian father, Ahmed. Before dawn on February 8, 2024, Israeli forces broke down the door of their home as they were sleeping, tied up the women and children, threw them against a wall, beat my 12-year-old cousin bloody, and took the men of the family hostage. Man was returned after 50 days by being thrown across the border. Israeli forces so brutally tortured him that he suffered a stroke that left him unable to speak. He had sores in his mouth from dehydration. He was missing chunks of flesh all over both arms so that his muscles and bones were visible. His wrists were shredded from the handcuffs. He still did not have his medication. He was in agony every day. We found out that Hashim and Burak, our two American cousins, who are still being held hostage by Israel, are also being severely tortured. The U.S. Embassy lied to us and said that the boys were getting, quote, slapped here and there, as if that was acceptable. But we discovered that Burak was so badly beaten that the Israeli prison authority broke a metal chair over his back. He has been deprived of medical attention and continues to be deprived, despite having broken ribs poking out of place. The U.S. government has forsaken them, fully abandoning its citizen hostages and abandoning any attempt to get them the help they need and secure their release. We heard much about the Israeli hostages, but never the Palestinian ones, and mine are American too. While one set of people is personalized, humanized, their experience platformed in detail, we are reduced to statistics, barely mentioned. Despite the enormity of our numbers and tens of thousands of hostages, feelings of fear are made equivalent to the decimation of our families. Hashim and Burak's mother suffers every day in agony, wondering if death is better for her sons than torture. But even in our deaths, Israel does not allow us dignity, and it does not allow us to know peace. In January 2024, Israeli forces raided one of my family's graveyards, where generations of hundreds of my family members laid to rest. The Israelis desecrated their graves, destroyed the field, and stole my family members' corpses. Among those bodies was Ammi Wadia, who was the leading elder of the family. The leading elder is incredibly well respected within the family and across the whole of the Gaza Strip. The Israelis stole his body as a personal blow to the spirits of my family, as a final assault on our dignity and of those who we honored in death. This assault follows us even here in our home of Illinois, where we witnessed the murder of 6-year-old Wadia al-Fayoumi, an American Palestinian child who was killed for nothing more than who he was, right here in our backyard. And yet, our state punishes us and retaliates against companies that refuse such horror, that reject the murder of children. In effect, our state, the home where I grew up, glorifies and validates the machinery of oppression that devastated and crippled me and generations of my family. where we have screamed in horror at the decaying flesh of our loved ones, where we have cried in despair over the tender children ripped away from us, where we have begged for mercy and a morsel of food. We are challenged with the Zionist perspective that our pleas for our lives are somehow dwarfed by the hurt feelings of those who hear our desperate pleas. How can it be a harm to oppose the destruction of my family's home? How can it be a harm to ask that babies in my family not be deprived of food? How can it be a harm to appeal for dignity in death? It is not a harm, but an erasure. It is a brazen retaliation by this state for seeking justice, an unashamed statement by Illinois that Palestinian lives do not matter, that our visceral pain at the tangible loss of life is insignificant, that we are easily wiped away. Illinois is an active participant in that cruel, dehumanizing erasure. Even this very committee, the fact that we are relegated to a subject matter hearing regarding this bill instead of voting on this bill is erasure. This bill was refused the normal process of a vote that all other bills undergo. We asked for this bill to go for a vote, as all other bills do, even if that were a vote against. That was denied. And that in itself is erasure. My heart breaks at the casual indignity that we are all forced to suffer as retaliation. I have visited Gaza, but I was born and raised in Illinois. It is everything I know. It is where I have manifested a life, and it is where I have always planned to continue to be. But with the current law in place, I am made small, stifled, suffocated, and discarded. I am stripped of rights other citizens of this state and this country are naturally afforded just as a function of the skin I live in. The seal of the state of Illinois bears the motto, quote, state sovereignty, national union. Sovereignty, by definition, is the authority of a state to make laws and govern itself without external interference. And yet, the current law places limitations on the fundamental constitutional right to free speech at the behest of Israel by a board that, as Representative Rashid stated, announced its interests as, quote, preserving Israeli sovereignty. Illinois cannot be said to be truly sovereign when it undermines a fundamental constitutional right by a law devised to preserve the sovereignty of a foreign entity. To live up to its own motto, Illinois must pass Bill 2723, repeal the law that creates an exception to free speech, and restore faith in its true sovereignty and interest in dignity. Thank you.
Thank you very much, and thank you for your testimony. I will open it up to questions now. First of all, does anybody in the chamber have any questions? Anybody online? God bless you. I have a couple questions, just real quick, for Mr. Goldwasser. You talked about First Amendment stuff. Your argument, I gather, is that this statute, as is right now, chills the First Amendment. How do you distinguish between political expression, stifling that, and what I assume some people would say would be discriminatory conduct, as opposed to just free expression?
Well, free expression covers political conduct, and that's what the United States Supreme Court said in Claiborne. If there is actual conduct, discriminatory conduct that goes beyond free expression, we have laws that are targeted towards discriminatory conduct. You can't discriminate in hiring against somebody because of their religion or race or nationality, but targeting Israel or any other foreign country to engage in an economic boycott is protected speech. It's protected whether or not that's the only country that you choose to target. There's nothing in our Constitution that requires citizens or residents of the United States to speak only on certain topics. It's what is forbidden is that the topics that they do choose to speak on or engage in politically motivated boycotts, they can't be punished for that. And that's what this law, the existing law, does. It punishes corporations for exercising their right to engage in politically motivated boycotts.
Okay, thank you very much. Thank you. Does anybody else have any questions at all? No, no questions? No down here? Thank you very much for that, and thank you for the testimony. So we're going to switch over to the opponents. Are the proponents now? Opponents, yeah, opponents, yeah. Did I say proponent? I meant opponents. So who would like to begin? Whoever you guys choose.
I'll go ahead and start. Good morning. My name is Dan Goldwyn. I'm the Chief Public Affairs Officer for the Jewish United Fund, Jewish Federation of Chicago, which is leading a coalition of hundreds of Jewish communal organizations, synagogues, and schools opposing HB 2723. Before I go any further, I want to thank members of this committee, starting with Chairman Vella, Subcommittee Chairwoman Manley, and Republican Spokesman Sosnowski, for your careful and thoughtful consideration of this bill. In 2015, the Illinois General Assembly unanimously passed HB 61, which pension funds in foreign companies. This was not a unique addition to our pension law. Illinois law also bars Illinois pension funds from investing in companies that offshore their headquarters, companies that doing business in Iran and Sudan, Russian and Belarusian companies, and companies that house children separated along our southern border. All of this is to say that aligning Illinois' pension investments with Illinois policy priorities and values has a long-held practice in the state. Another long-held practice in Illinois is to oppose economic and other forms of discrimination. The unanimously passed SB 1761, Illinois' Anti-Boycott, Divestment, and Sanctions Law, is an important tool Illinois deployed to prevent wrongful discrimination and to provide certainty and reliability to Illinois' economy. The Boycott, Divestment, and Sanctions movement, commonly known as the BDS movement, is not an innocent protest movement against a particular Israeli government or individual Israeli policies. The BDS movement and its founders have made clear that at its core, they do not believe Israel has a right to exist as a Jewish state. They do not support a negotiated two-state solution in which Israel and a Palestinian state can live side by side. To accomplish their goal, BDS supporters look for opportunities to isolate and ostracize Israel, Israelis, and those who support them. BDS-led actions BDS actions include calls to boycott or divest from Israeli companies and American companies that do business with Israel, including Illinois' own Caterpillar, Motorola, and McDonald's. In case you're wondering why McDonald's was targeted, it's because the franchises in Israel offered free meals to Israeli soldiers who were called up to defend Israel and to rescue hostages taken by Hamas. BDS also calls for removing Israeli professors from academic institutions, associations, and intimidating venues into canceling performances by Jewish Israel supporters, like Jerry Seinfeld when he recently performed in Aurora, and Matisyahu, who had his 2024 concert at the House of Blues just down the street canceled because of security threats. These are not the actions of a movement for peace. These are the actions of a discriminatory movement that wants to isolate Israel, Israelis, and their supporters. Recognizing BDS's discriminatory intent and its potential negative impact on Illinois' economy, Illinois lawmakers took the limited and constitutional step of ensuring that Illinois pension dollars would not be co-opted by the BDS movement. It is absurd for the BDS movement to now claim that their ability to protest Israel has been impeded by this law. There are monthly, if not weekly, anti-Israel protests in places including Chicago's Loop and the Magnificent Mile. Illinois State Treasurer Mike Frerich's home and family have been protested and harassed multiple times, as have the private homes of Governor Pritzker and Representative Brad Schneider. Proponents of this and other BDS initiatives show up regularly at hearings and gatherings to make their opinions known and to hold regular press conferences in Springfield. With the exception of protesting private residents, they can do all these things because their right to protest is, and always has been, constitutionally protected. Foreign companies, however, do not have a constitutional right to receive pension fund investments. Illinois' anti-BDS law has been on the books for over 10 years, and over that decade, there are two important facts to note. First, only 28 foreign companies out of the 578 companies are on the restricted list because they support BDS. 494 of those companies are there because of connections to Russia. All of those companies are listed on the public website to investigate. And second, since the law went into effect, its legitimacy and constitutionality have never been challenged in court. Instead, all we have is an unpopular and divisive attempt to repeal a law that passed the Illinois House and Senate unanimously. Advocates for HB 2723 will often repeat a fanciful claim that the anti-BDS law has resulted in some amount of lost earnings to the pension system. This, however, is not true. It is incumbent upon the Illinois pension systems as they have a fiduciary duty to report concerns with any laws or legislation that may negatively impact the system or their returns. To date, not one of our pension systems have ever noted or footnoted that the anti-BDS law has led to any loss of returns or inappropriately tied the hands of investors. The passions surrounding this bill and the events coming out of the Middle East are real and they're powerful. And I do not question the feelings or the lived experiences of those on the other side from me on the Israel-Palestinian debate. However, the question of who has the right to what land and under what terms will not be settled in Illinois and will not be settled by repealing this law. The future of the Middle East will be settled by what Israelis and Palestinians accomplish together in places like Jerusalem, Ramallah, Tel Aviv, and Rafah. What we can do here in Illinois is to continue to stand against all forms of discrimination, including that favored by the BDS movement. We can create an environment where supporters of Israel and Palestinians can work together to find common ground so that they can help their friends and loved ones who live in the region find peace and security. We can come together to address the real problems facing Illinoisans every day, like access to health care, adequate housing, healthy food, and good education. All the time, energy, and resources wasted on this attempt to repeal this limited and constitutional law is time, energy, and resources that could have been used to make lives better. It's instead what we had is more division and more acrimony. On behalf of Chicago's and the broader Illinois Jewish community, I ask this committee, and eventually, if necessary, the entire House, to vote down HB 2723.
Thank you. Next, please.
Good morning. My name is Sarah Van Loon, and I'm here in my capacity as Regional Director of the American Jewish Committee in our Chicago office. Thank you, Chairman Vella, Subcommittee Chairwoman Manley, Republican Spokesman Sosnowski, and the members of the committee for convening this very important hearing. At AJC, we work to advance the well-being of the Jewish people, to help secure Israel's place in the world, and to uphold democratic values for all. That includes engaging constructively with policymakers on issues that affect both the Jewish community and the broader fabric of our society. We are grateful for the seriousness with which this committee is approaching a matter that's both personal and consequential. Illinois has long taken a principled approach to aligning its economic practices with its values. The state's 2015 Anti-Boycott, Divestment, and Sanctions, or BDS law, reflects a clear, bipartisan commitment to oppose discrimination in all forms, including economic discrimination. As you've heard, this approach is consistent with Illinois' broader history of restricting pension investments in entities whose conduct runs counter to states' policy priorities. From AJC's perspective, the BDS movement is not simply about criticism of Israel or the Israeli government policies. Rather, it is a campaign that, in both practice and in principle, seeks to isolate and delegitimize the world's only Jewish state. Many BDS leaders openly reject Israel's right to exist and oppose a negotiated two-state solution. This reality matters because it underscores that BDS is not a vehicle for coexistence. It is, in fact, a barrier to it. It's also important for us to be clear about what Illinois' anti-BDS law does and what it does not do. It does not restrict free speech, nor does it prevent individuals from expressing criticism of Israel or engaging in protest. Those rights are constitutionally protected and they remain fully intact. What the law does is ensure that state pension funds are not used to support companies that engage in discriminatory boycotts against Israel simply because Israel is a Jewish state. In that sense, the law represents a narrow, measured, and constitutional policy choice, one that reflects Illinois' long-standing opposition to discrimination and its interest in maintaining stable and principled investment practices. It's also worth noting that nearly a decade after its passage, the law has functioned as intended. It has never been successfully challenged in court, and there is no credible evidence that it has materially harmed pension performance. Claims to the contrary remain speculative. They have not been substantiated by the pension systems themselves or by any expert. At a time of heightened polarization and rising anti-Semitism, it is especially important for policymakers to resist efforts that would deepen division without delivering meaningful benefits. Repealing this law will not advance peace in the Middle East, nor will it resolve the complex and deeply rooted Israeli-Palestinian conflict. Repealing this law will not change the real suffering of Palestinians, whether in the West Bank or Gaza or those here in Illinois with family there. It won't change that because this law does not target the Palestinian people. It governs how Illinois pension funds invest public dollars, and that's what's critical to remember. This bill will not alleviate suffering abroad or local anguish, but it will deepen fear among Jewish Illinoisans here at home. What HB 2723 would do is remove a clear statement that Illinois stands against discrimination. It would tell Jewish Illinoisans that state protections against anti-Israel boycotts are expendable at a time when anti-Israel agitation is often spilling over into anti-Jewish hostility. Instead, Illinois should continue to foster dialogue, support efforts towards coexistence, and address the pressing needs of our communities here at home. Illinois can focus on remaining a place where diverse perspectives are respected and where discrimination, economic or otherwise, is firmly rejected. On behalf of AJC and the communities we represent, I respectfully urge this committee to oppose HB 2723 and to uphold Illinois' longstanding commitment to fairness and principled policymaking. Thank you for your time and consideration.
Thank you.
Good morning. My name is Rebecca Weininger. I'm the Senior Regional Director of the Anti-Defamation League's Midwest region. Chairman Vella, esteemed committee members, thank you for having me today. ADL is the world's leading anti-hate organization, founded in 1913. Our mission is to end the defamation of the Jewish people and to secure justice and fair treatment to all. We are experts in anti-Jewish hate and extremism, and among many other things, we aggregate the number of reported incidents of anti-Semitism that occur every year in the U.S., and we calculate the devastating effects that boycott, divestment, and sanction, BDS policies, against Israel have on the institutions and the communities subject to them. I am here both as a leader of the Jewish community and as a Jew who needs this committee to understand what rising anti-Israeli sentiment is doing to Jewish communities in Illinois. I speak for the 86% of Jews in the United States who say that Israel is integral to our identity, and I reject those who seek to sow a false narrative of division in the Jewish community for this hearing. The BDS movement intends to normalize the idea that it's acceptable to single out and exclude Jews based on our connection to Israel. When movements work to systematically exclude Israel from economic, academic, and cultural life, they don't just target a foreign country, they create an environment where Jewish students, Jewish businesses, and Jewish families become targets too. Illinois Jews are already living through the most violent years since ADL began keeping track of anti-Semitic incidents in 1970s. In Illinois alone, anti-Semitic incidents increased by 177% over 2 years, from 121 in 2022 to 336 in 2024. The hateful rhetoric that leads to violence against Jews has been normalized, and the methodical exclusion of Jews from civic, social, and professional spaces is devastating the everyday lives of Jews in Illinois. HB 2723 will not improve the quality of Palestinians in Gaza or Palestinians in Illinois, but it will categorically impact the lives of Jews. The BDS movement targets both Israel's existence as a Jewish state and Jews worldwide, regardless of our actual views. With escalating anti-Israel sentiment powering the rise in anti-Jewish violence, legislation like HB 2723 sends precisely the wrong message: that Illinois does not, in fact, reject the BDS movement and its discriminatory origins. So I ask this of this committee: will this bill make the lives of Illinoisans better? This repeal is not about the law itself. Illinois' current law is narrow and constitutional. It simply ensures that state pension dollars are not used to support discriminatory boycotts. This repeal is not about free speech. Individuals, organizations, and companies can still express their views, they can protest, and they can support boycotts. This repeal is not about fiduciary responsibility. We know that the next intended step is boycotting Israel. This repeal is also not about Palestinian human rights. To be clear, Palestinian human rights are gravely important, and we are invested in working in partnership toward improving the lives of our Palestinian neighbors here in Illinois and around the world. Human rights are sacrosanct, and this committee should work every day to secure and protect those rights for every community. But this measure is not about that. It is instead about clearing the way to do what we know BDS measures do: serve as a pretext for boycotting Jewish businesses, dividing Jews into acceptable and unacceptable categories based on our views of Israel, and systematically excluding Jews from public life in Illinois. This committee should not tolerate anti-Semitism dressed up as a foreign policy critique, even when it comes from anyone, Jewish or not, who claims to be our allies. Instead, let's combat anti-Semitism in all its form and achieve the hate-free world that all of our children deserve. I invite everyone who claims to want peace abroad and human rights at home to join the real discussion about how to protect vulnerable communities in Illinois. You can support legislation that does not require disinformation, shoddy math, and excessive degrees of intellectual separation to wed the content of the bill to a proffered desired outcome. This committee should welcome ideas for effective ways to combat hate, not spend time on a bill passage of which will only result in division and marginalization. I ask this committee to learn from organizations that represent the Illinois Jewish community, such as ADL, about how dangerous it is to be Jewish right now, in part because of the rising anti-Israel sentiment being used as a dangerous social currency. I want you to hear about how we are forced to fortify our places of worship just so that we can be safe when we gather and when we worship. I want to tell you about the emotional toll it takes, not just on adults, but on our children who are choosing to hide their identities, putting away their Stars of David and kippot so that they are not victimized for being Jewish. This committee can choose not to pass legislation that will divide Illinois and make it even less hospitable to Jews. You can address hate and lower the temperature of the rhetoric against us. I ask you to spend Illinois' time and taxpayer money on laws that will raise up all communities, that are supported by data and brought in good faith. I implore you to oppose this bill, and I thank you so much for your time.
Thank you very much. I'm going to open up the questions. I have a question first myself. So one of your core arguments, it sounds like, is this, bill as is, or the law as is, helps fight discrimination. Could you kind of go more into how specifically it does that? Like, what's the mechanism of how it fights anti-Semitism?
Here at home,
Yeah.
here in Illinois,
Yeah.
by singling out Israel for boycott, the effect is actually on Illinois Jews. We have measured the impact, both financially, but more importantly, socially, of the BDS movement on Illinois Jews, and the excuse, the pretext that it is to actually boycott Jews here in Illinois. The effect is not, in fact, on Israel, but the impact is on Jews here at home when we use BDS as an excuse to exclude us publicly from civic life, from academic life, from social circles, and financially by boycotting our businesses, merely because we believe that Israel should exist.
Okay, so the argument would be that if the bill before us is passed, it will add to discrimination in Illinois of Jewish people, and the boycott would extend to them, basically.
Exactly, and particularly in a climate where anti-Israel sentiment turns into violence against Jews, we are very concerned about the rising number of anti-Semitic incidents here at home in Illinois.
Okay, thank you very much. I will open up to any more questions. Is there anybody on the, no, anybody here? No questions? No? Looks like there are no questions. I'm going to, yeah.
Thank you, Mr. Chairman. I don't have a question, but I wanted to extend a thank you to all of the witnesses who presented today. Very powerful testimony on both sides of this issue. I know it's an issue that will continue further discussion in the state, and so I wanted to recognize the sponsor and thank you for engaging in this discussion today. You know, as I look out at this room, we have very strong, very diverse opinions, all represented here in this hearing room. And I appreciate the sensitivity and symbolism of this topic and appreciate everyone who's here with phones out, with notes taking, with heads nodding or sometimes shaking, but this was a hearing that was conducted with great responsibility and decorum, and I think it's a testament to everyone here in this room on both sides of this issue that we're able to have this hearing, learn more about this issue, and do it in a way that is respectful to one another. So thank you, Mr. Chairman.
Yes, thank you, and I want to thank all the witnesses and the public. You know, there was a lot of concern that this was going to turn into what my grandpa used to call Donnybrook, like a lot of screaming, a lot of yelling, a lot of throwing of chairs. You've all done a great job of being not just good community members, but good witnesses and great people who could listen to this whole thing. And you're letting us, the people on computer and the people here in the room, hear from both sides without any emotion. Well, there was emotion for sure, but without any emotion from the gallery. And it was great to hear from Representative Rashid. And I am proud that this is, I understand that not everybody is happy that we're not having a vote today. I'm proud that this subject matter is the first subject matter that's been held on this. I'm proud of what we've done. And, we're going to take this information as a committee and mull it over. I have some more research to do for myself, and I think that some members of the community do too. So with that, thank you all very much. And at this point, I know Representative Rashid would like to make a quick closing statement himself. As long as we just keep it quickly.
I will keep it brief.
I don't want to turn this into a back and forth.
Thank you.
Okay.
Many of the things that we shared, I think, addressed what the opposition said, so I will keep it brief. I want to start with the sleight of hand of equating the measure protecting Israel from boycott to the other countries that were listed or the other restrictions that are imposed. A country domiciled in Russia or Belarus must be boycotted, whereas Israel is the only country protected from boycott. Those are entirely different categories. It's apples and oranges. I want to make that clear. foreign companies. They focused on foreign companies. I mentioned the Morningstar just down the street. I mentioned Ben & Jerry's. Well, sure, Unilever is a foreign company, but Ben & Jerry's is owned by actually 2 American Jews, or Airbnb based in San Francisco. And I'll just end with, the final speaker mentioned the intellectual separation that we are engaging in. The intellectual separation was entirely on the opposition. We engaged in by the opposition. I explained exactly what those settlers did to my family, what they did to Khamis Ayyad, the impact they had on my daughter, and how Ben & Jerry's boycotting them led to retaliation by our state. That is as real as it gets. I am frankly insulted that that would be called an intellectual separation. So I appreciate the opportunity. I do want to say on the record, this is one of the first legislative bodies in the country that is engaging in a hearing on this subject, where a bill defending Palestinian rights is being heard and debated and discussed. And I thank you, Chair, for that. I'll stop there. Thank you.
Thank you very much for that. There being no more business, the House International Relations, Tourism and Trade Committee will recess to the call of the chair. And I do want to say thank you to all you again.